So I've had a question from someone in Scotland, and they have explained how they are used to judicial oversight of powers of the Scottish Parliament. And so the question they wanted to ask is whether I think this will gradually follow in England and Wales. So I think the answer to that is very different whether we're talking about England or Wales. So I think with regard to Wales, I think we will see this following in the future. So we know that the Senedd Cymru, the Welsh Parliament, does have the power to make legislation. It now has very similar, though not exactly the same, powers of the Scottish Parliament, and there's also the same ability to bring an action of judicial review if you think a piece of Welsh legislation is beyond the competences of the Senedd Cymru. So I can see in the future perhaps there being more cases coming through where there are challenges to acts of the Welsh Parliament, the Senedd Cymru. But I think there's a slight difference in how these two operate. So if you look at both the Scotland Act and the Government of Wales Act, which set out the powers of the Scottish Parliament and the Welsh Parliament, both of them allow not only for you to have actions of judicial review after a piece of legislation has been enacted, but they also allow for a special reference procedure so that cases can go to the Supreme Court to look at whether an act of the Scottish Parliament or an act of the Welsh Parliament is within the scope of their powers. And this reference can be taken when the act has gone through all of its processes in either Scotland or Wales, but before it receives the royal assent. Now, one big difference is that the Welsh Government has used this power more frequently than the Scottish Government to make a reference up itself to the Supreme Court. So it will enact a piece of legislation, it will think it's within its legislative competences, but it will make a reference up to the Supreme Court to check beforehand if they think that there might be a possible argument that aspects of it might be out with competences, or when you've got a piece of legislation that has two motives, two purposes, one which is very clearly within competences, another where it says, well, you don't necessarily don't have the competence to do this, but it might cross over in different areas. So you have this kind of uncertainty in some senses. So it might be that Wales will continue to use that process, and that might reduce the amount of judicial review challenges you have brought by individuals afterwards. We'll have to wait and see. With regard to England, I think the answer to that is no. Mostly because we don't really have a distinct English Parliament enacting English legislation. So we used to be able to make that argument potentially when we had a system of English votes for English laws. So when you had a piece of legislation enacted in Westminster that would only have an impact in England, there used to be a process whereby that piece of legislation would need to be voted for both by a majority of English MPs and by a majority of all Westminster MPs. Now that system, English votes for English laws, was removed in July. So that doesn't exist anymore. So it's now even harder to say that this was perhaps passed by an English Parliament because it has this double process of English MP majority and Westminster MP majority than it was when we had the English votes for English law system. So English law is really enacted by the Westminster Parliament, and as we know, the Westminster Parliament has parliamentary sovereignty, and I don't think it's likely that this issue of sovereignty is going to be challenged in the future. So the potential challenge to parliamentary sovereignty when the UK was a member of the European Union obviously now is no longer there post-Brexit, though there are some aspects that can override national laws when we look at the Northern Ireland Protocol and citizenship provisions, but they're very small, unlikely to cause major issues apart from the Northern Ireland Protocol, which is incredibly complex, but I think it's something we need to keep an eye on to see how that operates in future. I think also, when we look at things like the Independent Human Rights Act review, there could be some suggestions coming through from government that rather than having a system where you might say we want to protect human rights more strongly than we find in the current provisions of Section 3 and Section 4, which rely on interpretation and a declaration of incompatibility, there are suggestions that perhaps sometimes they might go too far. So it might be, though we don't know yet because this still hasn't been reported, that there might be a move towards reducing the ability of scrutinising legislation through the Human Rights Act. So I think my answer to the question with regard to England is I really can't see in the near future a system where we accept an element of scrutinising English legislation, particularly because you cannot really separate English legislation from Westminster legislation, and because the sovereignty of Parliament of the Westminster legislation, so the sovereignty of the Westminster Parliament, is so strongly entrenched in the UK Constitution that I can't really see that changing in the near future.